What do you really need in order to justify a $1 million verdict in your medical malpractice case? You want to know what you need? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. You know, you read about all these verdicts coming up and it sounds as if they're outrageous verdicts. $25 million, $50 million, $100 million. And now you begin to wonder, wow, these people are really lucky. Look at this, they're getting all this money. Well, first of all, they're not getting all that money. Because what you don't hear about, what the newspapers and the media do not report, is all the things that go on behind the scenes to try and cut and reduce that particular verdict. And whatever decision the judge comes to, you don't hear about the defense lawyer appealing that, and again, asking a higher court, the appellate court, to throw out that verdict, or again, reduce it dramatically. You don't hear any of that. But all you see is in the newspaper and in the news that somebody was given millions of dollars for their injuries. And you want to know, hey, what does somebody really have to do in order to justify a $1 million or multi-million dollar verdict? Well, I want to take you through it because I think it'll be eye-opening for you, and I guarantee you'll have a different perspective than you did before watching this video. So what do you really need to justify a $1 million or multi-million dollar verdict? First thing that you need to show that your doctor was careless. You need to be able to show that you are slightly more likely right than wrong, that what you are claiming is true. That number one, your doctor violated the basic standards of medical care. That's the very first thing that you need to show. That means he was careless, professionally careless. So now, if you're able to show that, and the jury concludes that yes, you are right, they confirm that, great. What's the second thing that you have to be able to show? You have to be able to show that his carelessness was a cause of your injury. It doesn't have to be the cause, it only has to be a cause. In law, we call that causation or proximate cause. The jury has to determine that there is an actual link between whatever he did incorrectly or wrong or carelessly, and now that was a cause of your injury. That's the second thing that you have to show. What's the third thing? The third thing that will allow you to justify a verdict in your favor of $1 million verdict or multi-million dollar verdict is having significant injuries. Minor injuries are not going to cut it. We have to be able to show them that your injuries are significant, that they are disabling, that they are permanent. And we have to do it through your testimony and through medical testimony to show, yes, as a result of these injuries, you can no longer do the following things. You're unable to return to work. You're unable to do various things. You're going to be in pain for the rest of your life. You're going to need various medications for the rest of your life. You're going to be on narcotic painkillers. You're going to need multiple surgeries. You're going to need prosthetic aids and devices to help you get through your day. You're going to need visiting nurses to visit you each and every day. And now by showing them and understanding exactly what it is that you're going to have to go through and what you have given up, what you have lost because of this doctor's carelessness, now the jury can come to the conclusion that yes, we're going to give you all this money as a form of compensation for all of the harms and losses and damages that you incurred. That they're allowed to do. But now, even if the jury determines that yes, you are entitled to receive millions of dollars, guess what? Just because the jury gave it to you doesn't mean the doctor's going to take out his checkbook and right then and there write you a check and that's the end of it and say, I'm so sorry, have a great life. It doesn't work that way. None of it works that way. Instead, the defense attorney, the first thing he's going to do is he's going to ask the judge to throw out your entire verdict as being against the weight of the evidence. He's going to argue that the evidence does not support this verdict. And your attorney is going to say, wait a second, judge, we all heard the same testimony. Of course it supports it. The second thing he's going to do is ask the judge to reduce the verdict. Why? Because he's going to claim that your injuries are not worth and valued at this multi-million dollar value point. In all likelihood, the judge will tell the defense lawyer, listen, if you really want me to evaluate this, go ahead, get the trial transcript, prepare your legal research, put it into the form of a legal brief, send it to me. Then send a copy to your adversary, the plaintiff's attorney, and now he'll have time to reply. Then I will have time to do my research, and then I'll give you a decision a couple months down the road. Now, let's assume that the judge says, you know what? I'm not touching this verdict. It's staying as it is, which means that the millions of dollars the jury gave you stands for now. Do you think they're going to take this lying down? The answer is no. The defense is going to take this issue up on appeal to the appellate division, where a panel of judges are now going to evaluate whether there were errors of law made during the course of your trial. They're going to evaluate whether the amount of money that you were given is consistent with the testimony and consistent with what other types of cases of this nature have gone for, have settled for, as well as reached a verdict for. That's what they will do. So they will be faced with the same exact question. Should we throw this verdict out and have you start this trial all over again with a new jury? Or should we increase the amount of money that you were given? That's a possibility, assuming that they gave you a certain amount and now the appellate court says, hey, you know what? These injuries are so much worse than everything else we've seen. That's a possibility. On the other hand, they could turn around and say, you know what? We don't like the fact that they gave you $10 million for your future pain and suffering. That's not consistent with any other case we've seen. So now we're going to reduce that part of your verdict, the damages, to $5 million or some other number. And now you can either live with that or try the case all over again, and you can now present proof and have a different jury come up with a decision that may be different than what we're telling you. So why do I share this great information with you? I share it with you just to give you an inside look at what occurs in these medical malpractice cases here in New York. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're contemplating bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, then what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.